Okay. Okay, did you recall if there were any reasons for us to make corrections or changes to that report? He's not there. We lost him. He's. Okay, we'll call that case when he logs back in. If he logs back in. John Greyhouse. His attorney's not here. Oh, he's not here scheduled tonight. It is 9:30. Yeah. That's Mr. Pickling. Okay.
Sorry, I don't know what happened.
Okay, back on the record in the matter of the state of Michigan versus Jeffrey Bowers. I was asking you if there was any reason for us to make changes or updates to the report that your attorney went over with you yesterday.
We did talk again this morning because there was for the assessment that wasn't there, and he said, and also he said that the victim hadn't contacted him, but now I got that, so everything, if it's in the paperwork now, then everything should be fine. We did talk about that today, so that was all that was my only problem I had.
Yeah, I recall yesterday, your probation officer came upstairs, or the probation officer that authored the report did bring up the assessment and the other, I think the victim impact statement yesterday that was provided to your attorney once we received it, but he may have already spoken to you at that time. I do have the victim impact statement here in the file. But as to the remaining portions of the report, there's no reason for the court to make objections, is what you're saying? I mean, changes to that? Is that what you're saying?
Yes.
Okay, you can make allocution.
Thank you very much, Your Honor. I would begin by indicating that in my discussions with Mr. Austin, we found ourselves in agreement that would appear that Bowers is an excellent candidate for probation. He is employed full-time. He's been with, I don't know if it's his wife or, but they've been together for some 15 years. They live together. They have 2 children in common. He appeared at the pre-sentence interview, was respectful and thoughtful. He expressed his remorse for what had happened. And even the author of our report indicated that he was visibly upset when speaking. Probation is recommending a 12-month term of probation. Domestic violence program, we certainly believe that would be appropriate. Not necessarily given the facts and circumstances of this case, but because it's his second time at bat for domestic assault. Outpatient substance abuse program, what was found in his pocket certainly would warrant the court ordering the same, and random testing and maintain his employment. The hiccup, Your Honor, is not terribly unusual. This happens in these kind of cases. They're recommending no contact with alighted cats, and that is it's going to be difficult. I would respectfully request the court to modify that to say only peaceful contact, so that he can continue to remain in the home and take care of his children and so forth. If that would please the court, but beyond that, I would respectfully ask the court to sentence him consistently with the recommendations. Thank you.
a victim present today, do we?
We do, Your Honor.
Oh, we do?
Yes.
Okay.
She would like to give a victim impact statement.
She can give a statement. Ma'am, you can come forward. You can, if you stand right there, state your name for the record, please.
Checklist.
Okay, you can give your statement.
I just wanted to say that I think
Can you speak up just because the record has to be able to hear you?
I think that he should be able to come home. So he can be with his kids and myself. I think that charges were, they shouldn't have been charged for what they're trying to charge him with. He's a great father, fiance. Been together 15 years, nothing like this has ever happened.
You don't believe he should have been charged with domestic violence?
Yes.
You communicated that to the prosecutor's office? Oh, and then he's also was charged with other things that there's a guilty plea, I'm sorry, a guilty conviction of at this point by way of no contest plea. It wasn't just the domestic violence. You're aware of that?
Right.
Okay,
Yes.
but you're just talking about the domestic violence aspect. You don't believe that he assaulted you? Okay. I don't know why if that's the case by the prosecutor's office. And you didn't have a discussion about that beforehand?
Yes. We did.
I don't know.
I sent him the letter and everything. I talked to the prosecutor over the phone about it. They were the ones who informed me to write a letter so that it could be given to you. Way prior when all of this got started, so.
Okay, and I have your victim impact statement here. It looks like there was an email sent to Mr. Hannah yesterday. I'm sorry, it was received yesterday. You sent it on Monday. You indicated, to whom it may concern, I am writing this letter in hopes of Mr. Bowers being able to come home very soon. This whole situation has been taking way out of control to me. The situation that happened, I feel, was blown out of proportion. Mr. Bowers did not put his hands on me, and the scratch shown in the picture could have come from anywhere. I work in healthcare and I have been hit, kicked, scratched, spit on, and nothing like this has ever happened from PTS. What is that? PTS. Abusing me.
Patient.
Oh, okay, PTS abusing me. No one has ever been penalized for it. I feel it was taken out of context because alcohol had been involved. We were both intoxicated and had a misunderstanding. We hardly ever argued. Jeff is a wonderful father and a very hardworking man. He's been going through a lot lately with his health, and I think with all of this, he is getting stressed out because he also hasn't been able to work the way he would like. I was working a lot of overtime to try to provide both income for a while, and he didn't feel or like feeling like he was less of a man having to sit back and watch me working so hard, like he couldn't provide for his family. This was definitely been a lesson learned, but so unfair to our children. We all have suffered in so many ways. I don't know how this will help bring him home, but please let him come back home to our family. We miss him dearly. Is there any additional impact statement that you want to provide him? Did your client want to make a statement?
I'm sorry, Your Honor, pardon me.
Did your client wish to make a statement at all?
I'm sorry, I don't know.
Mr. Bowers,
Yeah,
you're muted. If you want to make a
Yeah.
statement, you can do so this time.
okay. I just wanted to admit that I made bad decisions with the things that I've done with the alcohol, with the drugs. I backslid because of they just came out and told me that basically that something can happen to me anytime, that sarcoidosis has that I got diagnosed with sarcoidosis, cells in my lungs, my spleen, my heart, and and they said it spread it rapidly. So it kind of it threw me off, and I wasn't doing it. I wasn't making it better by drinking and doing the drugs, but I don't know. I felt like I don't know. I felt like I was covering it up. And with this situation, not that I would have rather been this way, but it has opened my eyes and let me see what was going on, what I was doing wrong, and for me to make the decision that I made, to even have that stuff in my pocket. I mean, I I know that could have caused me to lose everything, and that's my life. I mean, I work hard for them. I'm a full-time father. I do a lot for the kids. You know, I have 6 kids. I have 5 grandchildren, and I try to be there for them all. But my youngest now, that's at home, I try to show them the right way, and I know I wasn't doing it at the time. I was making the wrong decision. But like I said, this time that I've had away from my family, it's really been tough. But I've had time to open my eyes and see what I need to do. And I've even asked for the help from Crystal because I said I do need it because I want it better, and I definitely don't want to be away from my family. And I mean, I just know, it's gonna be a tough road, but like since the 25th, I haven't touched anything. I don't want to touch anything, and just going through the right assessments that with the programs, hopefully that'll help me out a lot more, and I can keep on going and be able to be there for my family and not make this decision that I was making and actually help myself with my health.
Thank you. I've had an opportunity to review the pre-sentence report, the recommendation, and obviously the victim impact statement. We have the victim present, and ma'am, you can take a seat. Victim present today. And I want to first address these statements or the perception that this is a situation that's been blown out of proportion. The facts that was relied upon in order to have a no contest plea entered came from the police report without dispute. And those facts indicated that when the police arrived to the address and the location of the alleged incident due to a report of a fight or something that sounded physical, that they made contact with the alleged victim, and that the victim did report to the officer that the mark on her neck was from being pushed out of her chair by the defendant. And so it doesn't matter to the court. It should not matter to the court or to the prosecutor's office or to the public when it comes to what you do in your job. I don't care if you have to put yourself in harm's way as a part of your job and that you may end up pushed or kicked or assaulted. We see assaults from the hospital and healthcare all the time. So I can't speak to why this particular victim's experience didn't involve a prosecution if she was being abused or assaulted as part of her workplace. But just because you have suffered abuse in one area does not mean it's okay for you to suffer it in your home. That's a cycle of abuse. That's a psychological mindset. And there should be a standard that you should set in your home for yourself, that you will not allow anyone to place you at harm's risk, whether it's at your job or in your home. You're also giving an example to your children. You have 2 young children, a male and a female. When you allow this type of behavior, whether you believe it's minor or not, to happen, you continue that cycle of abuse. It's the court's position, and it's their job and their goal to help break those cycles. And so I recognize that the victim feels like this is minor. The court doesn't believe it's minor. And this is also a situation where, Mr. Bowers, you've been in this situation before. This is not the first time you've engaged in assaultive or threatening behavior with someone you were in a dating relationship with or someone who lived in your household. And so there's something that you have to address for yourself. I recognize too, and my condolences to you for your recent health issues, and I recognize you have a long journey as it relates to recovery or treatment, and you're going to need your family support. But if family support means that I have to put family members at risk for you not being able to control your temper or your behavior when your temper flares up or when you're not feeling yourself, then I have to make a decision that's in the best interest of the safety of the people that you're going to be around, and not in your best interest for your support. That's not what the court has to balance when it comes to safety and security. And so I wanted to address that first. I do have your substance abuse assessment now, which we received late yesterday. The report from probation was recommending that you do a term of probation, that being 12 months. You are not eligible for special status under 769.4A because you do have a previous domestic violence conviction. However, it does appear that you would be an appropriate candidate and that you should attend outpatient substance abuse program and submit to random alcohol testing and obtain employment. The court believed that that's an appropriate recommendation. I will adopt that recommendation. You will be sentenced to 12 months probation. While on probation, there is a requirement that you submit to random preliminary breath testing and urinalysis testing, and you have to pay the fee for that, okay?
Robert, did you hear the court?
Yes, I said, okay.
Okay,
Hello?
thank you. Yep, I can hear you now. Okay, and then you also are not to use, purchase, or possess any alcohol, marijuana, or controlled substance unless you have a valid prescription. You're not to purchase a firearm, ammunition, or weapon of any kind. You're not to engage in any assaultive or threatening behavior. And according to my report, you are currently employed. That's correct?
Yes.
Okay, so you will be required to maintain employment during the course of your probation. I am going to order that you participate in an outpatient substance abuse program. You'll provide verification of that to your probation officer, okay?
Okay.
You're not to be at any bars or nightclubs while on probation. I will allow peaceful contact with the victim in this matter. It's a $30 per month oversight fee that you're responsible for. You had a conviction for 3 counts, and each count is a $75 crime victim rights fee plus $50 state minimum cost of each count. 12 months of probation at $30 per month. $360 for oversight fees. I'll waive discretionary fines and costs. Your total fines and costs is going to be $735, and you'll be able to make monthly payments on that, okay?
Okay.
you have any questions so far?
Yeah, those are, where would I make those payments?
Excuse me?
Payments? I would make them to the, where would I make those payments?
You'll make them to the court at the criminal traffic counter, or you can make them online. You'll be in contact with our probation department because they're gonna go over this order and they'll give you further information, and they'll even tell you how much you're gonna be responsible for paying each month in order to be compliant. It's about $62 that you need to pay per month in order to remain compliant, okay?
Okay,
Okay, there's an advice of rights as to early probation. Those rights would include that you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs, except for domestic violence, criminal sex crime, and stalking offenses, or the offense where the defense of guilty but mentally ill was asserted. You may be eligible for early discharge. You are on probation for domestic violence, so these rights would not apply to you. If they did, you would have the right to request early discharge once you complete half the original term ordered by the judge, so long as you completed all of the required programming and you have not had any violations within the 90 days preceding that request. Do you have any questions about the right to request early discharge from probation?
no, Your Honor.
Any additional matters for the record?
Just briefly, Your Honor, you ordered that random alcohol testing be ordered as part of probation, but the people would also be requesting that random drug testing take place as well due to the charges that you put to for meth and cocaine.
I ordered random PBT and your urinalysis.
Oh, I'm so sorry.
It was standard, it's already on there, so it's standard, he will be tested for both.
Understood my apologies.
No problem. Any additional matters?
Nothing for the people.
Nothing from the defense, Your Honor. Thank you.
Thank you. Good luck to you, Mr. Bowers.
Thank you, Your Honor.
I think it's done.
We're ready to proceed on Anthony Davis. That one.
On the record, in the matter of the people of the state of Michigan versus Anthony Davis, file number 21-03352, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Attorney John Abbott, the Public Defender's Office, representing Mr. Davis. He is standing to my right.
Yes. Okay, Mr. Davis, how are you?
I'm wonderful, Your Honor. How about yourself?
I'm pretty good. Happy New Year.
Same to you.
Okay, today was the date and the time that was set for a preliminary examination. My understanding is that the necessary witnesses have failed to appear, and the people are moving to dismiss without prejudice, and there's an objection under MCL 764.26A to destruction of your arrest records. Do you understand that? Okay, do you have any questions about that? Okay, the case will be dismissed today. The people do have the right to reissue the charge against you. Can you give them a copy of that, please? To issue the charges against you within the statutory timeframe if they would regain contact with the necessary witness, okay?
Yes, Your Honor.
Any additional matters for the record, counsel?
Nothing for the people. Thank you.
Nothing from the defense. Thank you.
Thank you. You're all set. Yes. On the record, in the matter of the people of the state of Michigan versus John Greyhouse, file number 23-03639, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
This is Bobby Ficklin appearing on behalf of Mr. Greyhouse, Your Honor. P 78523. Good morning.
Good morning, how are you?
I'm well. How are you?
I'm pretty good, thank you. Okay, let's see. I'm not a waiver appearance. No, did you file your appearance with the court, Mr. Pickling?
Yes, I did, Your Honor. I filed it in person at the arraignment.
See what they did. His appearance is in the file. It's not in the system. Okay, they stuck it in the file, they just didn't put it in JIF, we'll make sure it gets updated. Today was the date and the time that was set for a preliminary examination. My understanding is that there is going to be a waiver of the timeline.
That's correct, Your Honor.
And why is that?
Well, I received discovery on yesterday, and the discovery document was 625 pages. So I did contact the court and Ms. Petrosky to set the exam to at least to next week. And she had no objections to resetting the exam.
Okay, and if you discuss with your client his right to have a preliminary examination within 21 days of his arraignment?
Yes, Your Honor.
Mr. Greyhouse, you understand that you have the right to have your preliminary examination within 21 days of the date that you're arraigned?
Yes, I do, Your Honor.
I understand the purpose of having that timeline is to make sure that you can accelerate or to take advantage of your right to a speedy trial. You understand that?
Yes, I do, Your Honor.
Are you willing to waive the 21-day timeline so we can reset this for another date?
Yes, I am, Your Honor.
February 29th at 9:30 work for you, Mr. Fickling?
Yes, it does, Your Honor.
Respectfully, Your Honor, our investigating officer is going to be on medical leave and will not be available next week.
After Wednesday, Monday or Tuesday.
I just said it for February 29th.
I'm sorry, say
February
again.
29th.
Sure. I'll be on crutches, but I'll be here.
I said it for February 29th at 9:30. Any additional matters for the record?
I think for the people, thank you.
No, Your Honor. None for the defense.
Thank you. You're all set for today.
Thank you. Have a
I'll
good
get you
day,
a
everyone.
copy of your notice if you need one, okay?
I'm sorry, ma'am.
You need a notice to appear
No, you said February 29th?
at 9:30.
9:30?
Yes,
I'll be here.
thank you.
Thank you, ma'am.
You're free to log off, Mr. Greathouse. Mr. Nickel, we're gonna have to bring your client upstairs because he was put on the writ list, so we'll bring him up.
If I could just be given just one moment, I'm gonna have to give this to someone and I'll be right back. Sorry.
Record in the matter of the people of the state of Michigan versus Douglas Edward Morren, file number 22-01038. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant who is standing to my left, or to my right, I apologize.
How are you, Mr. Morren?
Good, how are you?
I'm doing well, thank you. Okay, today was the date and the time that was set for preliminary examination. My understanding is that there is a plea offer. I have a plea sheet, sir. It says that the people are offering for you to plead guilty to an added count 2 of operating while intoxicated, a second offense, and that they will dismiss count 1 of operating while intoxicated, third offense. For a complete and accurate understanding of the plea offer.
Yes, ma'am.
Did you want to accept that offer?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
You can put your hand down. I do have an advice of rights and plea information sheet. It has today's date on it. That's your signature, sir?
Yes, ma'am.
Did you read this document?
Yes, I do.
Understand the rights here?
Yes, I do.
You willing to give up each of these rights today?
Yes, ma'am.
You understand that you have the right to proceed to a jury trial?
Yes, ma'am.
You understand that you have the right to the presumption of innocence. So you're innocent until proven guilty. You understand that?
Yes, ma'am.
You have the right to require the prosecutor to prove your guilt at jury trial by proving each element beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront in court and cross-examine any of the witnesses or accusers that are called against you. You have the right to call your own witnesses to your trial or present evidence that you believe further of defense to the charge being brought against you. You're willing to give up each of those rights?
Yes, ma'am.
Anybody threatening you to get you to give up those rights and plead guilty?
No, ma'am.
Has there been any promises that have been made to induce you to enter a guilty plea?
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer.
Yes, ma'am.
You also may need to report a conviction on a future job application if you plead guilty. Do you understand that?
Yes, ma'am.
And also, there could be impact on travel or immigration status if you enter a guilty plea on this. So you may not be able to travel to certain places that don't accept these types of convictions. You understand that?
Yes, ma'am.
As to the added count 2 of operating while intoxicated, second offense, how do you plead?
Good.
Are you pleading guilty because you believe you're guilty?
Yes, ma'am.
Factual basis?
Thank you, Your Honor. Mr. Morris, on February 26th of 2022, were you operating a vehicle upon a highway, that being South Martin Luther King Boulevard and West Kavanaugh Street in the city of Lansing, Ingham County, state of Michigan?
Yes.
And at that time, while you were operating a vehicle upon that highway, was your blood alcohol content, or had you been drinking before you had been operating that vehicle?
Yes.
All right, and you came in contact with the Lansing Police Department, correct?
Yes.
And they took your blood to be analyzed for your blood alcohol content.
Yes.
And do you dispute that the results of that blood test was 0.327 grams of alcohol per 100 milliliters of blood?
No.
Okay. And you knew you were drinking alcohol before you operated the vehicle, correct?
Yes.
Your Honor, I have no further questions.
Any questions from the prosecutor's office?
Oh, Your Honor, thank you.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. Your matter is set for sentencing February 22nd at 9 a.m. You leave here, you're gonna go downstairs 1 floor to the 5th floor, so that you can meet with our probation department, so they can prepare the court with a pre-sentence report and recommendation about how you are to be sentenced. I don't know if you've already undergone a recent substance abuse assessment, but you will be required to do so before sentencing, so that the probation department can use that in formulating their recommendation, okay? Do you have any questions today? We'll get your notice to appear if you've not gotten it yet, and you'll be all set to go downstairs. Any additional matters for the record, counsel?
Thank you.
Nothing for defense.
Thank you. Okay, and then we are running. Aquino?
More likely, yes, we're gonna be running that one. I have to talk it over with the prosecutor.
I'm bringing Aquino up right now.
Okay.
Who is this here?
This is Triplet.
Triplet, okay. Mr. Nichol? Oh, absolutely. Okay. Mr. Nichol, are you there? He might not be there.
She had, because she was in Buchanan, she had some stuff there,
Mhm.
because I was court officering over there before I came over here, and she had a few things over there, but she said she had 3 separate courts today.
Yep, I get it. And then I saw Miss Wanji peek in, so I know she's in the building. I just have not seen Milk all day.
Judge Ward's courtroom is full of people, so I don't know if they have matters in both courts, possibly. Buchanan is done, and Flores is done, yeah. So, but Ward's is packed, Judge Ward's courtroom.
Well, she can only do one case at a time. So,
Do you want me to go down and see if anyone's available?
yes, please.
Okay. Look and see what we got.
So I can't speak for Ms. Donnelly, but Mr. Pfeiffer said he will be about 5 more minutes. He is in a circuit court Zoom hearing.
Okay, yeah, he was right in there.
Yeah.
I know whoever she was looking for, she called them on the phone. Speak to her today? Oh, okay, well, I guess she knows you're here. She's right in the hallway. I don't know if you saw her out there. Hi, Ms. Wanji.
Good morning, Judge. Good. Happy New Year to you.
Same to you.
Thanks.
Ms. Wanji has
Patrick here and Anthony Phillips.
Phillips is in custody. Are we running Phillips? Do you know? We are running?
We were planning to run. I think that I'm gonna defer to the prosecution.
Oh, okay. She's just stepped right out. She'll be right in. Yeah.
No one has seen Milks. Somebody tried to call him, I guess. And nothing.
Now we have prosecutor, but we don't have Ms. Wanji.
I'm so sorry. It's like herding cats around here today.
It really is. Just on Thursdays and Fridays.
And a little bit chaos, you know.
or start the week, because it's been a short week, so.
Yeah. We would have like.
Mr. Nicola, did you need to talk to Mr. Triplet?
No, we can conduct the PCC and get a new PE date, and then I can go out to the jail to visit him, I think tomorrow, to kind of
Okay,
fully explain what's going on.
okay. Okay, on the record in the matter of the people of the state of Michigan versus Antonio Triplet, file number 23-03764 FY, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Triplet.
Okay, Mr. Nickel, today was the date set for your client to have a exam, but I know that you were recently assigned. And we said we would treat this as a probable cause conference. So I just wanted to address the timeline, and I don't know if you have received discovery or not.
I have received discovery, and so we would just ask the court set a preliminary exam date. And I have plans to get out to the jail tomorrow to provide Mr. Triplet a copy of the police report now that I have it, and discuss how to proceed with the preliminary exam with him fully.
Okay, Mr. Triplet, you understand that you have the right to have a preliminary examination within 21 days of the date you're arraigned?
Yes.
You were arraigned on December 20th, but your attorney was not appointed immediately, so that took some time. Plus, we got to factor in the holiday. So due to that, the court's going to find good cause to go beyond the timeline and reset this for a new date, okay? And then your attorney's going to come out to visit with you, okay? Next week. Does next week work for you, Mr. Nickel? Well, I don't know if they do have to get their witnesses though. Subpoena.
I could make next week work if the prosecutor can get subpoenas in time.
It's probably not enough time, so we're gonna do another week. Can do February 16th at 9:30. February 16th at 9:30, okay for you?
There's nothing in the remainder of January.
There's nothing in there in January.
Okay. I can make February 16th work.
Any additional matters for today's record?
Nothing for the people. Thank you, Your Honor.
Nothing further, Your Honor.
You're all set. Thank you.
Thank you.
Yes, but who should we bring up next? We're running.
Your Honor, Aquino is going to be an adjournment request from both parties. I believe that we were both ready on that. Ms. Allen is going to be on the whole process with her client, but she just informed me that we didn't.
Okay, so we can bring up Aquino, and are we running Phillips?
We're ready, but I think that the prosecutor has a motion.
Okay, we'll bring up Phillips and Aquino.
Thank you, Your Honor.
Okay, let's see. Wait, what? I just realized this.
Sorry.
What?
I
This
drew
is
there's two
July
cases,
2021.
want to make sure I'm in the right place and everything.
What is this? Were these like discounted or something? I'm confused.
What is it, every month?
It started in July.
What?
And it only goes to June. What? Someone must have got a discount on these. It started last July,
Oh, wait,
Okay.
23.
It goes to June of this year.
That won't work.
Oh.
Let me take my old one back. At least I have this at the bottom. That goes
So the
into the
offer
web
would be
calendar.
Commissioners Tab 1 and 2. And this-
Okay, on the record,
I have the
in the
second.
matter of the people of the state of Michigan versus Destiny Johnson, file number 23-02906 FY, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Destiny Johnson, who is present and standing at council table.
How are you, Ms. Johnson? I'm doing well, thank you. Today was the date and the time that was set for a preliminary examination. Counts of delivery, manufacturing of the drug. How are we proceeding on these?
Thank you, Your Honor. Your Honor, there's been an offer extended to my client to participate in the drug court. Based on that, we're going to waive our preliminary examination and proceed up to circuit court. Well, should be a screen where she will be screened and hopefully admitted into the drug court program under further negotiation.
That's an accurate statement. People would also be waiving our preliminary examination and ask that the case be bound over as charged to the circuit court.
Thank you. Okay, and then Ms. Johnson, you understand that you have the right to have a preliminary examination in the district court? You understand that the purpose is to require the prosecutor to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You wish to unconditionally waive your preliminary examination? Okay, and that's your signature on this document? Anybody threatening you to get you to waive your examination?
No, ma'am.
Any promises being made in exchange for a waiver?
No, ma'am.
Okay, you understand that you can't change your mind and that you're making this decision without any promises being made, correct?
Yes, ma'am.
Okay, your bind over date is going to be January 17th. That's the date the circuit court will get the file from the district court. That's not a date that you need to appear in court, okay? Your next court date will be a pretrial. Mr. Carter will be made aware of that date. What's your address?
492 Star, ARR Avenue, Mayfield, 489.
Okay. You make sure you stay in contact with your attorney. Bond in this matter, 2,500 personal recognizance will continue. Any additional matters for the record?
Thank you.
Nothing for the defense. Thank you, Your Honor.
Thank you. They're gonna bring up the other, Mr. Mills. Welcome to court in 2024.
Thank you, Your Honor. I assume you realize what my.
Well, I was looking for you. I said, hey, where's Mr. Mills? I don't see him.
Mhm.
And then we did an APV. No one saw you in the entire building.
Yep, yep.
And
There's
we
good
knew
reason
that-
for that. Mhm.
We said, that's not good.
No, no.
Because he's got an exam here. And
But you know I like to make a dramatic entrance.
we do, don't we know,
That's
man?
how I,
Don't we know?
as you know.
What, the way to start 2024, huh?
It's something.
Okay, so I'll let you all deal with that. And then
I think we're just gonna be running Mr. Kane today mostly, or continuing Mr. Kane today. I believe that's gonna be it.
okay, sounds good. He's in custody. And then Boseman is gonna be reset.
Both I've got here, we're talking about that right now. I think we're gonna come to a resolution.
Oh, okay, sounds good. On the record in the matter of the people of the state of Michigan versus Mark Aquino, file number 23-03744 FY, council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of defendant Mark Aquino, who is present and sitting to my right.
How are you, Mr. Aquino? Today's the date that was set for a preliminary examination of possession by felon and assault with weapon and 2 weapons counts. How are we proceeding?
Your Honor, both parties are requesting an adjournment today based on new evidence as well as potential resolution of the matter.
Ms. Donald,
Yes, Your Honor, that's my understanding as well.
you talk to your client about his right to have an examination within 21 days.
Yes, Your Honor.
Okay, and so, Mr. Aquino, you do have the right to have a preliminary examination within 21 days of the date that you're arraigned. You were arraigned on December 20th. And so, in order to adjourn this matter, I would have to go beyond that timeline to reset it. Are you willing to waive the 21-day timeline?
Yes, ma'am.
Anybody threatening you to get you to do that?
No, ma'am.
February 22nd at 10. February 22nd at 10 a.m. Do you have any questions for the court?
No.
Any additional matters for the record?
Yes, Your Honor. The last time we were here, the court ordered that the defendant's jail privileges be revoked due to claims that he was contacting the victim. There are 2 things. First, he has continued to contact the victim as recently as 8:35 a.m. this morning from lockup downstairs. Secondly, it appears that at least as of a couple of days ago, he still has his jail privileges. I see that he was still doing phone calls as well as video visits as recently as the 29th, which was after we had the last hearing. I would note, in interest of fairness, the video visits in his name are not to the victim, they're to a Melissa Schaub. I don't know how to pronounce that. But given the fact that he has worked to try and evade detection, we believe that if he is given an opportunity, he will take it. I also have another phone number to block from the jail.
Okay.
Your Honor, it's my understanding from Mr. Aquino that his phone privileges were revoked. It's somewhat confusing how the jail handles this, but from what I've been able to tease, his phone privileges have been revoked, which means he can't even make a kite to medical if he needed medical attention. But because the court allowed him to communicate with his attorney, he still has access to parts of the jail's electronic system that allows to message people or maybe even do phone visits with other people. But Your Honor, I guess my what I want to put on the record is that the way the jail is doing it is a very piecemeal type of way, and I'm just concerned that if we revoke, when we revoke his privileges, that it revokes other things that he's entitled to, like filing a grievance against the jail. He can't do that right now because he doesn't have access to the phone. So that's my only concern, Your Honor, is that by taking away or trying to take away the privileges that we don't want him to have, we're taking away the services and privileges that he should have. That's my only concern.
I have an excellent solution for that. He could stop making calls that he's not supposed to make, and then we wouldn't have to take any of his privileges.
For the record, there's been 103 since the last year.
I'm not a victim.
I'm not even sure why you're talking out of turn in the courtroom. Thank you. Okay. Have you been able to confirm if his calls were blocked?
I'm trying to pull them up now, but of course, this is the moment where their website is having difficulties in pulling them up. I know that he was still making phone calls as of the 2nd. I know he was still able to reach out to commissary because they're able to still reach out to commissary. I see that he sent e-messages to someone who wasn't Miss Donnelly also on the 2nd, and that he was making video visits through the 29th.
It's really mind-boggling to me that everyone at this point in Ingham County Jail should know that Mr. Pfeiffer is going to listen to and watch this stuff. So why in the world, after the last hearing, would you do anything that would put you under his radar again for further bond violation and potential charges to be brought against you? Is mind-boggling to me. Being charged with 4 felonies must not be enough. Obviously, having a bond set at $150,000 cash surety is not enough. Obviously, restricting your phone privileges is not enough to send the message that we need to send to get it through your head, so that you can understand what's going on. What do you need from us? Well, how can we say it to you in a different way that you can understand? Can you hear me? How better, do you want me to write it out for you?
No, I understand clearly.
Okay, I expect you to comply then.
Yes,
This is
ma'am.
not rocket science. You're under the restrictions of the court, as you have some very serious felonies pending and very serious allegations pending against you. And this doesn't help. You can talk to your attorney. This doesn't help your defense by you violating court orders pending your case being heard in court. Get it together. I've already restricted phone calls. He's allowed to make phone calls and communications, obviously with his attorney. I don't know what's going on with Ingham County communication system. There's no reason why he shouldn't be able to make a kite. And he shouldn't be able to even get commissary just because his phone privileges are restricted. If that's an issue, Ms. Donnelly, you let us know. The system should be far more sophisticated than that. They just built a multi-million-dollar new jail. So this is ridiculous.
Your Honor, for the record, I can see that he has been able to make requests for commissary, housing requests, and issues as recently as yesterday at 2:12 p.m. So if that's what he is telling Ms. Donnelly, it does not appear to be accurate.
It could be some manipulation going on, I don't know, but the records don't lie, at least they haven't. And so, again, I'm going to have Mr. Pfeiffer confirm that his privileges have been restricted. We want that done today.
I'll contact the jail as soon as I get back to my office.
And you needed to add an additional number, you
Yep,
said?
I'll write it down hand to the court.
Thank you.
Ms. Donnelly already passed that number.
Okay, that additional number will be restricted. There was a young lady in the back that had something to state. I don't know if she needs to talk to you privately, but she shouldn't be blurting things out on the record in courtroom.
Is that number there, please, with 517?
This one here.
Don't tell me. 517. Sorry, that one on the left. 517.
Oh, okay, so.
Sorry, I forgot that the jail phone number technically begins 517.
Okay, thank you.
Thank you, Your Honor.
No problem. Any additional matters for today's session?
Not from the people, Your Honor.
Not for defense.
Okay, and we should bring up who next? Phillips? Mr. Milks, are you ready to go on the record with yours?
Yes, Your Honor, we are ready to go.
On the record in the matter of the people of the state of Michigan versus Tommy Boseman, file number 23-02387, counsel appearance.
Mr. Prosecutor, Paige Petrosky on behalf of the people.
And good morning, Your Honor. Steve Milks on behalf of Mr. Boseman. I'm finally here on both files 2905 and 23.
In 2024.
In 2024.
Thank you. Today was the date set for a preliminary examination and a PA 53 contempt hearing. How are we proceeding on this?
Your Honor, it's my understanding, I don't want to put words in the mouth of the prosecutor, but we are looking to unconditionally waive the preliminary examination in both files, Your Honor, pursuant to a plea offer extended by the people, which was pleading guilty in case 2387 to count 1 and count 4, reducing the have to habitual fourth down to habitual second, and dismissing case 2905 in its entirety, as well as the balance of the charges in 2387, and that there would be some ongoing negotiations regarding possibility for treatment. It was also our hope and understanding that we could possibly dismiss the contempt hearing, if that's okay with your court, based upon this waiver, and again, if that's okay with the prosecuting attorney as well.
That was also my understanding of the offer in this case, and we would not be objecting to the dismissal of the PA 15 hearing, or excuse me, violation. Excuse me, and if defendant were to waive, the people would also unconditionally waive our preliminary examination and ask the case be bound over to circuit court.
Thank you. No worries. I was just reviewing to see what the bond violation was because it's so old. The bond violation was essentially not to commit a crime while released, which it's not been convicted of anything, so we wouldn't be able to meaningfully proceed on that anyway. So that would be dismissed if waived. And so that's how you want to proceed today? You understand that you have the right to have preliminary examination in each of these files and that you have the right to require the prosecutor to put forth sufficient evidence to establish probable cause that a crime was committed in each file that it contains a felony and probable cause to charge you with those felonies. You understand that? Yeah. Mr. Mills. Your approach.
Yes, Your Honor.
Anybody threatening you, Mr. Boseman, to get you to waive your examination?
No, Your Honor.
Any promises being made to you in exchange for a waiver?
No.
Thank you.
Thank you. Thank you.
Thank you.
Your Honor.
Find your waiver to be freely and voluntarily made. Your bind over date is going to be January 17th. So that's the date the circuit court gets a file from the district court, okay? You do not have a court appearance on that date, all right?
17.
That's the date they're gonna get the file from this court. Your next court date is gonna be a pre-trial though, and that date will be sent to your attorney, okay? Do you have any questions? Okay. Bond and file number ending in 2905 is 75,000 cash surety. That will continue. And then bond in 23-02 387 as 5,000 cash surety. That will continue and the court will dismiss the PA 53 violation. Any additional matters for the record?
Nothing from the people, Your Honor. Thank you.
Nothing from the defense. Thank you, Your Honor.
Thank you. You're all set.
Mr. Bowers said they're come off the sentencing.
I'm confused. Mr. Phillips? Okay, on the record in the matter of the people of the state of Michigan versus Donald Ray Phillips, file number 23-03148, council appearance.
Prosecutor Paige Petrosky on behalf of the people.
Morning, Your Honor. May I get the launch for Mr. Phillips? Who sits here at council table?
Today's the date and the time that's set for preliminary examination. One count of controlled substance possession, habitual offender, second offense notice. Are we proceeding to exam?
Your Honor, the people be asking for a good cause adjournment due to our reporting officer, Officer Jamil Bakri. He has his daughter has a medical appointment. He was unable to reschedule, so he's unable to be here today.
It's fine.
You know, we were ready to have a preliminary exam. So on behalf of my client, I would ask for case to be dismissed. I did explain to him that the case would, if the case is dismissed, it would be without prejudice, and the people can file it again.
I'm inclined to believe that they are going to file this before he can make it back to the Ingham County Jail if this is dismissed. So it's not in the interest of judicial economy to dismiss it based on the reasons provided by the prosecutor, which is that the officer had a family medical issue that he needed to attend to. I'm going to grant the good cause request for an adjournment, go beyond the timeline so that I can reset this matter.
February 22nd at 10.
February 22nd at 10 a.m. We'll get you a copy of your notice to appear. Do you have any questions? Any additional matters for the record?
Nothing for the people. Thank you.
Nothing, Your Honor. Thank you.
Thank you. You're all set. Yes, we gotta finish Kane, but did Ms. Donnelly?
She didn't come back up after
But she has a guy back here.
Aquino.
She has Mr. Taylor here.
She does.
He just wants to know what's happening, I think. Okay, well, she's downstairs?
I think so.
Yeah, she left when
Yeah.
he left.
Oh, okay. She left her stuff here or is she coming back?
Yeah, her stuff is here. so I'll
Oh,
get it
she's
back.
coming back then, no worries. Okay,
So you
Kane can be brought up. On the record, in the matter of the people of the state of Michigan versus Anthony Taylor, file number 21-03078, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Anthony Taylor, who is present and standing to my right.
Okay, Mr. Taylor, last, it's your turn. Okay. Okay, I have a plea sheet here. Says that there was an offer extended to you for you to plead guilty to an added count 2 of attempting, resisting, obstructing a police officer, that the people will dismiss count 1 of fleeing and eluding 4th degree. That's a complete and accurate understanding of the offer.
That's correct.
Yes.
And that's what you understand your offer to be?
Yes,
You want to accept that offer?
I do.
Please raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
And you can put your hand down. Okay. You have the right in this matter to proceed to a trial. You have the right to a jury trial. You have the right to the presumption of innocence at your trial. You're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront in court and cross-examine any of your accusers or any witnesses called to testify at your trial. And you have the right to call your own witnesses to testify at on your own behalf or present evidence at trial that you believe further a defense to the charge of fleeing a vehicle. You understand that?
I do.
Have an advice of rights and plea information sheet. There's a signature. Is that your signature?
It is.
And so you understand the rights that we just went over, which are the rights that's listed here.
I do.
You want to give up each of these rights?
I do.
Has anybody made a threat to you to get you to want to waive your rights and plead guilty?
No.
Anybody promising you anything in exchange for a guilty plea? Are you currently on probation or parole?
No.
I understand that a guilty plea could result in a conviction that you may need to put down on a job application, or you may need to report a conviction to your current employer. You also understand that the conviction could result in impact to any travel or immigration status that you might be seeking. As to the added count 2 of attempt resisting, obstructing a police officer, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty? Factual basis, counsel.
Thank you, Your Honor. All right, on July 20th of 2021, Mr. Taylor, were you at Richwood near Orchards Court in the city of Lansing, Ingham County, state of Michigan?
I was.
At that time, you were operating a motor vehicle, correct?
Yes.
All right, and you were in an apartment complex parking lot, correct?
Yes.
When Michigan State Trooper initiated a traffic stop?
Yes.
All right, and did he, when you got out of, when he tried to initiate a traffic stop and you got out of your car, right?
Yes.
And did Trooper Golden tell you to get back into the car?
Usually, yes.
And you knew he was a state trooper by his uniform in the vehicle, right?
Yes.
And whether was he using? Do you remember if he was using sirens or lights on his vehicle?
No sound or lights.
Okay, but he did direct you to return to your vehicle, correct?
Yes.
And you didn't do that, correct?
No.
Okay, and at that time you actually ran from the traffic stop, correct? All right, and then Trooper Golden, he was able to catch up and arrest you?
In the building, yes.
All right, Your Honor, I have no further questions.
He was in a police vehicle?
It was.
He just didn't, you said activate his lights or sirens?
No lights or sirens.
No. So what, but you knew he was trying to pull you over?
I seen him in my rearview mirror, but I didn't see any lights or sirens or hear no sirens. So I kept going, and then when I absolutely knew I was the one he was behind me at the time, I was already at my apartment.
What's the attempt resist obstruct then, or even the fleeing and eluding? I don't have a factual basis.
Well, Your Honor, the fleeing and eluding was amended to a resisting obstructing last week, so that should I probably didn't look at the police sheet close enough if it says that she was dismissing the claim, because I think we amended that already last week.
Yeah, but that's what the offer was, that he's doing attempted
Attempted.
resisting obstructing, so you're either gonna have to give me factual basis to that, or you can give me a factual basis to the original charge, but I don't have that either. If he didn't know, if an officer's behind me and he doesn't activate his lights or his sirens, I may question if he's pulling me over too.
Your Honor, there were lights. I've asked it away.
You can't give me the factual basis. He's gotta tell me.
Yeah,
If he
I
doesn't
understand.
remember,
So-
then maybe if he lacks memory for some reason, then maybe you should talk to the prosecutor about a no contest. But he's saying he said unequivocally, there were no lights or sirens, and that he did not know that he was being pulled over initially. And then once he was certain he was being pulled over, he stopped, he said.
Okay, so.
Sounds like a law-abiding citizen.
All right.
Based on that statement.
Your Honor, I'll just continue asking questions then. So it was your apartment complex that you lived at that you were pulling into?
Yes.
Okay, and were driving that a vehicle without a plate, correct?
I was.
Okay, you knew that the car didn't have a plate?
I should have found my first mind, but yes.
Okay, so.
Should have what?
I was going around the corner to get a cigarette.
Oh, but that was the question. The question was, you knew that it didn't have,
Yes,
okay,
yes.
thank you.
All right, and so, so when you pulled up to park at your apartment, or before you parked at your apartment, did you notice the Michigan State Police vehicle behind you?
I did.
Okay, and so when you pulled in, and when you stopped and got out of the vehicle, Trooper Golden he stopped and got out of his vehicle, correct? All right, and that he commanded you to return to your vehicle. All right,
He did, yes. Okay.
And you heard that command, right?
I did.
All right, and you did not follow that command, right? And you're not disputing that it was a lawful command, correct?
Okay, very good. Any additional factual basis?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea, find your plea made freely, voluntarily, and intelligently. The matter will be set for sentencing February 22nd at 9 a.m. When you leave here, sir, you need to go down to the 5th floor so you can check in with probation. They can get you set up for a pre-sentence interview, okay? Okay, do you have any questions at this time, sir? Okay, any additional matters for the record?
Nothing for defense.
Thank you, you're all set. Mr. Taylor will get you downstairs to probation, okay? Nice bag you have there, Mr. Moats.
Thank you, Your Honor. Accessorize, accessorize.
There you go. Today's the date and the time. Let me call the case actually. On the record in the matter of the people of the state of Michigan versus Patrick Michael Kane, file number 23-03549.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Stephen Mills on behalf of Mr. Kane, who is present and standing to my right.
Okay, and how are you, Mr. Kane?
Doing all right.
Okay, very good. Today was the date that we continue the examination that began back in looks like December. Actually, we began this in November, but we had an issue with the subpoena on December 15th. So are you ready to continue today?
Yes, Your Honor.
Any preliminary matters before we call witnesses?
Nothing from the people.
I believe there was already a sequestration order put in place, Your Honor.
Sequestration order was granted and that will continue. How many witnesses do you have?
Today, I have 2 witnesses present, but I believe I will only be calling one.
Okay, sounds good.
Thank you.
Thank you. Be seated. You can call your witness.
Sorry, and I apologize. This is just a new lawyer question. If there's a sequestration order in place, if the victim's mother is the victim or the witness who testified last time, is she able to be present in the courtroom or because of sequestration?
Sequestration, she
Separate.
cannot be there.
Correct.
That's correct.
Just wanted to correct. Thank you. I will get Ms. Head.
Yes.
I know the. Oh, but when you say that he has to come because of the 50. Or should he?
Is he here?
He's in lockup.
Oh, he's in custody. Are you gonna go talk to him?
I am.
Give me just a minute. Give her a copy of that. Copy, take it to him. Yeah, we needed a witness for that, so. Yes.
And the witness didn't wasn't present for that.
Yeah, but she doesn't have to be here for the show cause, though.
But yeah.
Oh, I was talking to Ms. Nash. Yeah, the show cause was for a city man. We'll bring him up later for that.
Thank you.
Thank you. Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat, ma'am. There is a microphone in front of you and the lady behind you is my court reporter. She has to take down everything being stated here today in the courtroom. So your responses must be verbal. They must be loud and clear, so you can't do head nods and head shakes, okay?
I'll do my best.
If you don't, we'll just ask you if it's a yes or no, okay?
Yep.
And so also, if there's an objection from either side, you will stop speaking immediately. I'll make a ruling on that objection, and then I'm going to tell you if you can give that answer or not, okay?
Yes, ma'am.
State your first and last name and then spell both of them.
Janie Head, Jamieheada.
Very good. Okay, you can proceed, counsel.
Well, Right at noon. So good afternoon, Ms. Head. Where were you living on November 25th, 2023?
4245 West Jolly Lot 237, Lansing, Michigan, 48911.
And is that in Hingham County?
Yes. Or Eaton. No, it's confused. It tells me different ones. It's like right on the border. Google said Eaton.
All right. Do you own that property?
I paid monthly mortgage. I paid own, yes. Mortgage,
Are you allowed to be in that residence?
yes.
And who lived there at the time?
Myself and my daughter live there.
Yeah, I'm sorry. At this point, Your Honor, may we approach, you're right? Yes. Sorry, thank you. I guess just, thank you, Your Honor. I know we just approached, perhaps clearing up potential jurisdiction issues before we move any further might be prudent to see whether or not we need to go forward any more with this case. Obviously, I'm not trying to tell the prosecutor what to do at this point, but purposes of efficiency and economy here, I think that might just be.
Yeah, that's no problem. I was gonna ask the question if you didn't ask anyway, so I'll let her continue, but she can follow up with jurisdictional questions.
Thank you.
Oh, yes. I was like, yeah, I'm gonna continue the questions. And so, what were you doing early in the morning of November 25th?
Sleeping. And tell Patrick to move it.
And were you asleep at the Jolly Road
Yes.
residence? Did you stay asleep the whole night?
Until he came and knocked on the door. Yes.
And who came and knocked on the door?
Patrick.
And how do you know that?
We met over a decade ago and we've been dating.
And dating like in a romantic relationship?
Yes.
Were you in a romantic relationship at the time?
We were talking, but I had to keep everything separate because he wasn't supposed to be around my daughter or anything.
Okay. And why wasn't he supposed to be around your daughter?
Because he has a record.
What kind of record?
Objection, Your Honor. This is getting another act at this point. It's been properly introduced.
Okay, did you want to respond to the objection as to why this information should come in?
Yes, so it's not being used to address Mr. Kane's character in any way or state that he has any sort of propensity for any sort of acts towards Ms. Head because of any sort of outside conduct. Instead, it's laying a foundation for future identification and conversations that took place between Ms. Head and law enforcement.
Okay, and the question was why he wasn't allowed to be there or be at that property?
Contacted brother.
Or was there no?
There was not a no contact.
Okay.
I'll Kristen,
you retract the question. Okay, yeah. Sounds good. You don't need to answer that.
So when you saw Patrick knocking, or you heard him knocking on your door, what did you do?
I wasn't fully awake. I opened the door up and let him in because I woke up from sleep to a pounding on the door. I thought it was a wellness check or who knows.
So when you said you thought it was a wellness check, did you know who he was?
I just heard banging, open the door, but once I knew it was him, I let him in and Hope was just waiting for him to go because I kept telling him he wasn't supposed to be there.
Did you want him to be in your home at that time?
No.
And why not?
Because he's not allowed in my home. I'll leave my daughter.
And he doesn't live there?
No. He was living there when I lived in my apartment, and then he went to jail. And when he went to jail, I had to.
Objection, Your Honor, I'm sorry, this is again calling for other acts.
Okay, I think
And
we could
it's-
probably move on. We know he wasn't there. I don't know why this information would really be germane to the charges there. There's nothing that suggests that this is the issue involving a breaking or entering or anything of that nature. So I'm not sure why we need this information.
So what happened after he came inside?
He was mad I didn't wake up earlier. And he just wanted to hang out and talk and I don't know, just be at my house. And I kept telling him I couldn't be there. And then then we just, I don't even remember why we were fighting. We started fighting and he just got physical and I couldn't, the whole night was trying to just get him out of my house.
Okay. So when you say that before that you were fighting, was that verbal fighting?
Arguing.
Arguing? Were you the only person who was present in the residence besides Mr. Kane?
Yes.
How did Mr. Kane react when you asked him to leave?
He would say no and or just ignore me.
So while he's present in your house or in your home, what happened next? After you were arguing?
We were arguing, he grabbed me, threw me around a little bit, he got my lip busted. I went bruises on my back, stuff being thrown into the house and the wall and.
Okay, so I'm gonna slow down where you go through that bit by bit.
Oh, no.
Oh, I'm sorry. So when you say he was throwing you around, where was he touching you?
Like grabbing me by my arms.
Did you want him to do that?
No.
And what did he do once he grabbed you by your arms?
Just hugged me.
And then you said that he had split your lip. How did that?
Yes.
Was that a yes or a no?
Yes, ma'am. He kept covering my mouth so I couldn't breathe because my nose was so full, stuffed up that every time he covered my mouth, I couldn't breathe and I thought I was dying. And that made my dentures cut into my lip and split my lip open. I believe the cop has pictures of the cut that went across my whole lip.
Yeah. I was gonna do this later, but so I have a couple pictures. So you actually no, I'm gonna. So when you said that he put his hands over your mouth and nose.
Just my mouth. I have really terrible sinuses. I can't breathe out of my nose, and I told him that I couldn't breathe out of my nose. So as soon as he covered my mouth, I just kind of flipped because I can't breathe, and it was trying to live.
Yeah. Do you remember where? Actually, how did your body feel when he was covering your mouth?
Like I was dying.
And were you able to take as deep a breaths as you wanted?
No, it was very hard to get breath in.
And how did you react to him covering your mouth?
I kicked, screamed, scratched his eyes, and just did everything I can to get him back off me.
Did that work?
For a second or two.
And then what happened?
And then it'd go again.
Did you have your cell phone with you that night?
Yes, but every time I went to do anything, he took it from me.
And what were you trying to do with it?
Call for help.
Who were you trying to call?
Anybody.
See, I think there's some tissues there. If you
No.
want. Okay, you can take your time. You said call for help?
Mm-hmm. Yes, ma'am.
What happened when you tried to call for help?
He would take my phone away from me.
And I'm sorry, I might have missed what you said. Who, when you were calling for help, who was help to you?
I tried to call anybody. I tried to call 911, he got the phone away from me. finally my mother called and I yelled at my phone to call the cops and it somehow erased, texted out and I hit the button before he got it. So she got that message.
Okay. How many times do you think that Mr. Kane took your phone away from you? Were you
4 or 5?
4 or 5 times? And that was while you were trying to call someone? Did he know you were trying to call someone?
Objection, Your Honor, calls for speculation.
Yes, sorry.
The objection is that it calls for speculation.
Did you, yes, sorry. Did you tell or inform?
Objection sustained. Thank you.
Did you tell Mr. Kane in any who you were trying to call or what you were trying to do?
He saw who I was trying to call and I told him. And I told him he needed to leave because he had to leave him. And he said he wanted to just resolve everything, but it started covering my mouth. It was just, that's too far.
So you were able to get a text through to your mother?
Yes.
What happened after that message was able to go through?
The cops. It took him a couple, maybe not even 5 minutes, once he heard the cops coming and he left, and then they came right after he did.
And you spoke with police when they arrived?
Yes. And they sent an ambulance to take pictures and everything.
Okay. How did you feel when he left? And can you, oh, okay. So I'm going to show you a picture. It's been marked as People's Proposed Exhibit number 1. May I put you on it?
You may.
You can hold it or do whatever you need to look at it. Do you recognize what's in this picture?
Yeah, I mean.
And how do you recognize it?
That was the morning that we thought.
And does this picture accurately represent what you looked like when you spoke to police?
Yes.
On November 25th? People who to admit People's Exhibit number 1.
Any objections to people?
No objection, Your Honor.
People's 1 is admitted.
Can you describe what's in that picture?
Well, my eye's not related to him. My eye was bad before.
Your Honor, I'm sorry, objection at this point, it's sort of invading the province of the court, and the court can see the photo, having her describe it, I guess, isn't. There's nothing that she has or she's explaining at this point that the court just can't see from the photo itself. It's invading the province of the fact finder, essentially.
Don't we usually have exhibits admitted by having them explain what's in the picture?
When it was explained, Your Honor, and that the foundation's been accurately laid and everything, it's just at this point, we've got a photo and I mean, it shows what it shows. Her explaining everything is no different than the court just looking at it.
Okay, your objection's overruled. You can continue.
So let's looking at that picture, let's kind of start at the top of your face and work down. Where is there something that's not normal on your
my
face?
My mouth is swollen.
Okay. And how did it get that way?
From being constantly pushed down and trying to, when I was holding my mouth shut.
Does it normally look like that?
No. Like I said, it was, I had scabs along the whole upper side of my lip.
And then are there any other injuries you can see in that picture?
In this picture, no.
And then I'm going to show you another picture. This is People's Proposed Exhibit number 2. See it?
Yes.
And do you recognize what's in this picture?
Yes, this one showed my face more puffy, and I had slight handprints on my throat, and that's what they were trying to take the pictures of. They only lasted a couple of days, so I didn't take another picture because it didn't get any darker.
And does this picture accurately represent what you look like when you spoke with police that
It
on
does.
November 25th?
Yes.
People moved to admit People's Exhibit number 2.
Any objections to people too?
No objections, thank you.
What's admitted?
So we're gonna do the same thing that we did with the picture before. Can you point out something that is different about your face than how it normally looks?
Mainly my mouth was all swollen and hurt. Yeah, I would just say my mouth, because you can't see any swelling on my throat or anything, so.
Okay. And you had said that they were trying to take pictures of handprints.
Yes.
Why were they trying to do that?
Because I had a hand.
Objection, Your Honor, this again calls for speculation, trying to assess what the photographer was taking pictures of and why.
Do you want to respond to the objection?
I'll rephrase.
Thank you. Objection sustained.
Did you communicate to the first responders or the police any sort of injury to your neck or throat area?
I told him he had grabbed me and thrown me, and he grabbed me by the arms, he grabbed me by the throat, he was holding my mouth shut. So it was all very sore to touch and all swollen at the time. So that's why it looks.
And is that how your face and your neck normally look?
No.
Did you tell police where Mr. Kane lived?
Yes.
And remember that address right now?
3501 Brighton Drive. Oh, Glenwood. No, Brighton Drive, Lansing 48901. Glenwood is the side street.
And did you provide them with any other information about him?
His car, I think they asked about what he drove.
Okay. And what did you tell them?
He drives a gray four-door Malibu, and he's usually in his car. He doesn't like people he lives with, so he's usually sitting out and hanging out in the car.
And that's what you told police?
Yes.
So you said you had known Mr. Kane for, you said about a decade?
Mhm.
And that you had been in a romantic relationship?
Not the whole time, though.
Oh, not the whole time.
Just the last year.
Would you recognize him if you saw him today?
Yes.
Is he present in the courtroom?
Yes.
Can you describe where he's located in the courtroom in an article of his clothing?
He's wearing a red jumpsuit.
Let the record reflect that Ms. Head has identified the defendant.
Any objections to identification?
For purpose of preliminary, Your Honor, none.
Identification is noted.
Further questions?
Ms. Head, I have a question. Your address 4245 West Jolly, that's lot 237?
Correct.
Okay, you indicated briefly that you believe it's on the line that it may be Eaton County?
Yes, some of my paperwork that I have received, it all says Eaton. Actually, not some, all of it says Eaton County, so I don't understand.
Okay, so you believe your address is in Eaton County. Is it less than a mile from Ingham County? Or
Yes.
more than a mile?
I would say less.
Okay, thank you. Cross-examination.
Thank you, Your Honor. Good afternoon, Ms. Head. You came here today with your mother, is that correct?
Yes.
And she was here at the last day for the preliminary examination, is that correct?
Correct.
Since then, the two of you had conversations about her testimony here in court, is that right?
Just as she came, and we couldn't figure out why. I've never been subpoenaed.
And on your way here, did you discuss what to expect or what was gonna go on or what questions she was asked or whatnot?
No,
And I want to go to the date of November 24th, so just the day before.
Mhm.
Now, that day you were in the hospital, is that correct?
correct,
And you were there because you had some injuries to your face, is that right?
my eye,
You had some injuries to your eye there?
yes,
Okay. And that was caused by something other.
yeah, something went in my eye and it scratched it all up and it's not healing.
Okay. Seems like it's healed up at least since then.
Oh, no, I still can't see out that eye.
Really? Okay.
Colors.
What's that?
Colors, I can see colors.
See colors. Just it's hard to see objects or
Yep.
something. Okay. Since it's difficult to see, does that kind of affect hand-eye coordination a little bit?
No.
Not being able to see out of one eye?
Mm-mm.
Is that a yes or no?
No, I'm sorry, no, I've been doing everything like normal.
It doesn't hurt depth perception at all?
No, sir. I was a little off on putting the key in the hole the first couple days, but I got that now.
So if a day or two afterwards, it'll still kind of affecting your ability to put the key in the key slot?
Yeah.
Is that fair? Okay. You own a dog, is that correct?
Correct.
And on 11/25, the dog was present in your home, is that right?
Yes.
And little dog?
Medium.
Uh,
Australian Shepherd.
Australian Shepherd. At the time, was the dog still little or young, I should say?
Oh, it's young. It's just at its full size. It's about 40 pounds. Comes to my knees.
What's the dog's name?
Charlie.
All right, and you said that the dog was with you that day on 11/25, is that
Yeah,
right?
he was in the kennel, thankfully.
Now
And then
sorry, you indicated to police that you take medications, is that right?
I take an antidepressant.
Okay. Well, specifically, you said it's necessary for sleep issues, is that right?
Oh, yep. I have antidepressant and trazodone and yes,
Okay. Antidepressants and trazodone, is that right?
yes, but I don't take my sleep medicine as much. Everybody knows I just don't sleep very often.
So it's hard for you to fall asleep, is that right?
Yes, but when I do, I'm usually out.
Okay. Now that day, you indicated that my client and you were having an argument inside your house, is that right?
Is that a
Is that a yes? or-
Yes, sorry.
No worries. We'll remind you.
I do it all the time. It
I'm
makes you feel any
quiet.
better, and I've been doing this for well over a decade. So regarding having the argument, as you were your ongoing argument, you told police that there was a period of time where you actually just kind of fell asleep. Is that right? Sorry, is that a yes?
Yes, sir. I fell back asleep because he was there for like 4 hours and he'd sit down and then he'd get up and we'd start fighting. And
So in the midst of this ongoing argument, you just kind of passed out.
well, we were sitting down on the couch and I was waiting for him to leave because this wasn't the first time he had done this.
So while you're sitting on the couch, you
I
did
fell
end up just
asleep.
falling asleep,
Yes.
correct? Okay. And has this happened before where you just kind of fall asleep kind of in the middle of the day like that?
Yeah.
And does it ever happen where you fall asleep and wake up for an unknown amount of time later?
No.
Well, here you fell asleep for about a half an hour, is that right?
Yes, because I was waiting for him to leave, hoping he would just go.
So you fell asleep for about a half an hour though, right?
Sure, yes.
Now, while you're asleep, you do have this dog that's in the house as well, right?
In a kennel.
In the kennel. The dog was in the kennel the whole time?
I'm pretty sure it was Pat that let him out at the end, but Pat, he's afraid of Pat because he tries to kick him and he
Oh, I'm
went to bed
sorry.
in my
During
house.
the argument or while you were asleep, do you know was the dog in the kennel at that time? Or were you
Yes.
uncertain?
Nope, he was in the kennel when Pat was getting him.
No, when you fell asleep, at the time that you fell asleep, had the argument already become physical prior to falling asleep?
Yes, it came physical and it stopped. It went on and off all morning.
So there was physical fighting that occurred prior to you falling asleep. Is that right? Sorry, but yes.
Yes, sir.
And I'm sorry, I should have said, are you on trazodone right now?
I didn't take anything. I haven't, no,
You're not on any medications right now?
no, sir.
Okay. You indicated at that time too, you had a cold, was that correct? You said you had allergies or a cold?
Sinuses.
Okay,
I
I'm
had
sorry.
them all year long.
All right, so you have sinus issues?
Mhm.
Yes.
Yes, sir.
And these sinus issues already make it very difficult to breathe, is that right?
If, as long as I have either my mouth to breathe out of my mouth, I'm good. Yes.
And, but it makes it difficult to breathe through your nose at least, correct?
Correct. But I'm.
So your
a mouth breather.
normal, the ability to breathe through mouth and nose has already been sort of hindered by these sinus issues you have, is that right?
I wouldn't say so because I don't breathe that way. I'm a mouth breather.
Sinus issues make it difficult to breathe through your nose, right?
If you breathe through your nose, sure.
Does it make it difficult for you to breathe through your nose?
Yeah.
With
I
sinus
don't breathe through
issues?
my nose.
Does
Don't
it
even
make
try.
it difficult? And just the other question. Okay. Does it make it difficult for you to breathe through your nose because of your sinus issues?
Nope.
Okay. Now, when paramedics did arrive later that day, you refused medical treatment, is that right?
No.
Did you go to the hospital with them?
They checked me out and said I was fine and that they didn't see any reason for me to go to the hospital. Unless I wanted to go see about my eye for the second time.
And so based on their advice, you stayed home?
Correct.
Okay.
They told me what to
Objection, Your
expect.
Honor, non-responsive.
Objection sustained.
One quick moment. You indicated my client drives, I just want to clarify, my client drives a Malibu, is that what you indicated?
Pretty Saturn Aura. but yeah.
Okay, wait, that's
Sorry,
different from a Malibu.
You're right. I said Malibu this time, but it's a Saturn Aura and that's what I told the cops. I don't know why I was thinking Malibu. It's a 4-door gray with black windows. No carpet in the bottom. Seats are tore up. It's a Saturn Aura. If I look through my paperwork, I have the VIN number, the plate number, and anything else you need for it.
So you just have a little lapse of memory?
Yes, I get it confused because the body style looks like a Malibu.
Okay. And sometimes that can happen, I guess, with the medications that you take from time to time, that side effects sometimes.
No, it's just, I don't care about cars. So a gray 4-door car looks like a gray 4-door car pretty much.
And what was the street name that my client lived on?
Brighton.
One quick moment, Your Honor. Your Honor, I have no further questions at this time. Thank you.
Just briefly. So when the defendant was over and you had been arguing and you had said that you'd fallen asleep. About what time was it?
6, 7 in the morning. Over about 5, 4 or 5, and I was like halfway into it. And I just kind of go along with it, because he's done it before, thinking he would just leave again.
And did you feel physically tired?
Yes.
When you fell asleep, you said you'd fallen asleep on the couch?
Yes. Yes, sorry.
Why'd you fall asleep on the couch?
I sleep on my couch. I have a 7-year-old. I try not to be far from her, so I'm used to sleeping on the couch even when she's not there.
But when you were woken up, you were sleeping in your bed?
No, I was on the couch.
Oh, you were.
I was like right across the door, and I was like a loud policeman. My door is breaking off him. No.
No further questions.
Okay, I have some questions. As they relate to the alleged injuries, you testified that the defendant was throwing you around, he grabbed you by your arms, is that correct?
Yes, ma'am.
Okay, and that you ended up with a busted lip?
Yes, ma'am.
Okay.
It was pretty much a straight line right across my lip from where my dentures cut into them.
Okay, and that was caused by what?
Him forcing his hand so hard on my mouth.
Oh, okay, so he forced his hand over your mouth. Do you know about how long that took place?
Oh, he did it a few times, so
Okay.
however long it took me to fight it off.
Okay, did he ever place his arms around your neck?
No, maybe a hand, but not long, only enough to like push you up against the wall.
Okay. Push you up against the wall by placing his hand on your neck, you're saying? Okay, and then when his hand was over your mouth, did that restrict your airflow?
Yes.
Okay. Any cross-exam or redirect based on that?
No, Your Honor, thank you.
No, thank you, Your Honor.
Okay, you may be excused, Ms. Head. There's a sequestration order, so that means you can't discuss any portions of your testimony with any other witness, okay?
Okay, thank you.
Thank you. You can call your next witness.
Nope, you're good. You can go. The people call Officer Erica Haffley.
You can approach counsel. Okay, any additional witnesses?
No, Your Honor.
Okay, and are you calling witnesses today?
No, Your Honor, I think, just to reiterate, I know at this time, we will be conceding the fact that the address is within 1 mile of Waverly Road, which is the 1 mile, within the 1 mile rule of venue jurisdiction issues.
Thank you. You can make argument.
We heard testimony from Ms. Julianne Kemp, who's the mother of the victim in this case, and from Ms. Jamie Head. Both of their testimony clearly or make it clear that this incident took place on November 25th, 2023, that it took place at the 4245 West Jolly Road address, lot 237. And Ms. Head was able to identify Mr. Kane based off of their decade-long knowing each other for a decade and being in a year-long romantic relationship. Ms. Head's testimony established the elements to a probable cause standard for the charge of assault by strangulation or suffocation. While in this instance, it was not a strangulation, which is generally typical, the jury instructions provide that blocking the nose or mouth is a sufficient way of affecting a suffocation, so long as it was a forceful, violent, or offensive touching of another person, which very clearly this was. Mr. Kane put his hands upon his head in a number of ways, but specific to the suffocation, he forced his hand over her mouth multiple times, having knowledge of the fact that she had sinus issues, making breathing already something difficult. Having knowledge of those issues, he decided to exacerbate that and to take away her one remaining means of breathing, which is through her mouth. He was so forceful in his actions that he actually cut her lips with her dentures, or cut the inside of her lips, or caused them to scab up. And she was not able to breathe like normal. She did not want it to happen. She was scared. She thought she was going to die. And because of that, she was able to fight back. But it's very clearly that the elements of assault by suffocation were established. Those actions taken by Mr. Kane repeatedly were intentional. They impeded her ability to normally breathe, and they were blocking her nose or mouth. Next, both Ms. Head and Ms. Kemp's testimony established the elements for interfering with electronic communications. Mr. Kane, when he was able to see Ms. Head's phone, he was able to know what she was doing, and she was obviously trying to call for help. And when she was trying to use her phone to call for help, to call 911 or to call somebody, call her mother, he repeatedly, at least 3 or 4 times, took the phone out of her hand and threw it across the room, or got rid of it, or got it away from her. This prevented, or at least delayed, her ability to get help. This was through a phone line that she was authorized to use. Based again on the repetition of his actions and the context of the situation, it's clear that the defendant did this willfully, maliciously. He did this with purpose. He did this to stop her from getting stop her from coming. As further evidence by the fact that he said that he was leaving as soon as it was clear that police were coming to the residence. Further, the elements for domestic violence were also met. Because again, there is a previous romantic relationship between the defendant and the victim, Ms. Head. Ms. Head testified that she was forcefully and offensively touched by on her person by Mr. Kane against her will and intentionally done. And it was clear again by the severity of his actions that he intended to commit this battery or to make her fear that he was going to hurt her in some way. And again, based off of the injuries shown by her photographs and by her testimony herself and by the testimony of her mother, Ms. Kemp, who saw those injuries at a slightly later date in the future, defendant obviously had the ability to do those, to assault and batter her in this way. As such, people would ask that the court bind the defendant over on the charges of assault by strangulation or suffocation, interfering with electronic communications, and a domestic violence third offense.
Everyone see the exhibits for me?
Oh, my apologies, Your Honor. May I approach?
Yes.
I'm sorry, did you say domestic violence third offense?
No, it should just be count 3, domestic violence.
Oh, okay. Count 3.
Oh, no, there is an habitual offender 4th offense notice, actually.
Yeah, that was the habitual offender. Did you say domestic violence? If I just misheard, that's probably what happened.
No, I was based off of the testimony. Judge, based off of what the testimony established, I was going to add the charge of a domestic violence third offense.
Based off the testimony, he's been convicted of domestic violence more than one time. Is it what you're saying?
My apologies.
I'm sorry, I think I confused everything with my, did you mean that the habitual offender fourth notice? Is that what you were?
I didn't, but I realized that I made a slight mistake, so, please.
I see in the habitual offense notice, it states here on about November 13, 2021, he was convicted of the offense of domestic violence, third offense.
Yes.
She's already been, at least according to how this was charged, she's already been convicted of third offense domestic violence. He was just charged with domestic violence in this, though, habitual offender fourth offense notice. So I'm not following. I think all of us are confused now. Can you clarify?
My apologies. I was trying to I guess amend or add a domestic violence third offense as a felony charge, but I realized that I did not get
Okay, you making a motion to amend the domestic violence
yes
to a third offense. But that wouldn't be based on the testimony, though, I don't believe.
I would agree with that, Your Honor.
And I would also. agree with
Okay,
that, Your
sounds
Honor.
good.
My apologies.
Any further argument from you?
No, Your Honor.
Okay, Mr. Mills.
Thank you, Your Honor. And Your Honor, at this time, the defense would ask that the court dismiss the charges against my clients. People have not met their time. Your Honor, regarding count one, the strangulation allegations here, we got some pretty odd testimony regarding her ability to breathe, where she indicated specifically that my client allegedly put his hand over her mouth. And now I understand that she's saying that that was done forcefully or whatnot, fine. But then she was also saying that at one point it was because of her allergies, I think, through her nose, that made it difficult for her to breathe. She indicated very specifically that he only put his hand over her mouth, not over her nose. She said that because of her allergies, that made it difficult to breathe. Then when I started questioning her, it became, oh, no, I can breathe just fine. We had that lovely little soliloquy between the two of us, at which point she eventually said, oh, no, I can breathe just fine. So there's some real discrepancy there if she's saying that her ability to breathe because of my sinus problems, which is exactly what the prosecutor relied on, is the fact that my client knew that she had these sinus issues, knowing she had these sinus issues, which again, I don't think was actually brought in evidence. My client had any knowledge of this, but assuming so, it was because the hand was over the mouth and knowing that she had these sinus issues. That's what inhibited her ability to breathe, or I'm sorry, that's what makes this a strangulation. But then she indicated that no, she can breathe just fine. So
knowledge of a sinus issue is not an element.
Correct, Your Honor. But her ability to
What rule
breathe
says in paragraph or the fourth paragraph sentence, third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of blood or breathing by applying pressure on the throat or neck or by blocking the nose or mouth. Who cares if you have sinus issues?
Right. And that's my point either. The sinus point only matters to the extent that we don't know whether or not her actual breathing was impeded. There's some clear discrepancies in her
I
statements.
asked her.
The court did, but when I
very
asked her,
directly for that particular reason,
right,
because I believe that what was stated on her direct got a little confused in her cross. And I don't know if it was because her testimony in relation to your question about her sinus issues was something that should lack credibility, or if that she just really didn't understand or was defensive about the sinus issues. I don't know. I did think that exchange was different. I didn't understand why she told us that she had sinus issues, and that because of those sinus issues, him placing his hand over her mouth made it more difficult for her to breathe. Then when you asked her, did her sinus issues make it difficult for her to breathe? She said no, and that she doesn't even try to breathe through her sinuses. I don't know why that happened. I really don't. But do I believe that those interactions cause a question of fact? I do.
very good. I made my argument on that, Your Honor. Thank you. I was still asked that the court not find over on the electronic communication charge at this time either. Once again, we've got some serious issues regarding her testimony. Now, she said at one point she was able to text HELP to her mother. 911 is 3 digits. That's 4. The fact that there's serious credibility issues with her statements here. If she can text that, her ability to actually communicate, the fact she actually got a communication out there, Your Honor.
My recollection of that was that she was able to do that verbally.
My understanding is that
And
she
then
texted
press
that.
send before he snatched the phone. Because, you know, we all got Siri, we always got, hey, Google. I think that's what she said, not that she texted HLELP.
Well, then I think there's definitely a problem here, Your Honor, if there's no clarification on that. If she's able to actually communicate and get those communications out here, Your
Why
Honor.
did she say here, Siri, call 911, correct?
I don't think she said that, though.
She did not. She said that she was able to text, talk, or communicate verbally to her phone to call for help, is what she said.
Well, I
Not
had
just
that.
help, call for help.
Which I believe was sent over in a text message according to her mother's statement, Your Honor.
I read that's likely, but her statement today was that she was able to verbally tell her phone to call for help and then press send to her mom before it got too late. And if what she's saying is the truth, and that includes her saying that every time she tried to get her phone, he would take it from her, calling 911 for them to hang up wouldn't be very effective, no? If that's the truth. Because he's gonna take the phone and hang up.
I don't.
If that's what she's saying.
Correct. My point here, and I'm not trying to argue with the court.
I know, I'm just trying to understand your argument.
My argument here is that she was able to actually get a communication out. I think it was shown by the fact that, in my estimation of how she explained it, was she was able to, and that's just the argument I'm trying to make.
I agree. That's what she said. And I don't, if that's the fact that, let's say she had got a communication out and called Domino's Pizza and had them call for help, does that mean that she didn't have an attempt with somebody trying to make an electronic communication for her? She's trying to get someone to call for help. Who cares who calls for help?
Because it has to be the authorized communication here, Your Honor. And I think if nothing else, it's no different than when my wife took my phone away from me when I tried to call Domino's Pizza.
She's trying to call for help. She's not calling Domino's to order a pizza.
And
she's calling them to say, get me some help.
Correct. And I apologize.
I'm being held with outside of my will, which I don't understand why we're not adding that.
Right. The fact that she is trying to make, and whether or not she's trying to make an authorized communication, though, is the ultimate question here.
She said she tried to
get
her phone multiple times to make a call.
Correct.
When asked who she was trying to call, she said anyone for help.
Right. And
that's broad. Sounds like a question of fact as to who anyone includes.
Correct. And well, like I said, I was not trying to argue with the court, just for purposes of my record, for my arguments here.
I get it.
I'm just saying that
they're good arguments. They're great arguments, but they're like arguments for the jury.
I don't disagree, Your Honor. Like I said, I'm just trying to make my record at this point, just saying that I believe she had the opportunity to do so. She was not trying to make an authorized communication that was somehow prohibited from my client. It's just the argument I'm trying to make at this point, Your Honor, with full and all due respect to the court's views at this time. So for those reasons, Your Honor, I would ask that the court deny bind over at this time, dismiss the charge against my client. Thank you, Your Honor.
I think that it's pretty clear that I believe that we have questions of fact here. But if not, today was the date and time that was set for a preliminary examination, Mr. Kane. This is the conclusion of a 2-day preliminary examination. The burden is on the prosecution to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. This is not a trial. They don't need to prove each element beyond a reasonable doubt. Any questions of fact present today are best suited for the trier of fact, and that's over at circuit court, whether you have a jury or a bench trial. That finder of fact will determine the questions of fact. Today, we need more than just mere suspicion that the alleged crimes were committed. Count 1 is assault with intent to do great bodily harm, less than murder, or by strangulation. At trial, they would need to, and it states here, by suffocation, strangulation or suffocation. So particularly, and there was a portion of this jury instruction read during the argument at the court. The criminal jury instruction states that at the time of trial, the people would need to prove that the defendant committed a battery upon, in this particular case, Ms. Head, and the battery is a forceful, violent, or offensive touching of another person or something closely connected with that other person. Second, that the touching must have been intended by the defendant, that is not accidental, and it must have been against Ms. Head's will. It does not matter whether the touching caused an injury. Third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of blood or breathing by applying pressure to the throat or neck or by blocking the nose or mouth. Ms. Head testified today that on the date of November 25th, 2023, at the area of 4245 West Jolly, lot 237 in the city of Lansing, Ingham County, but within the 1 mile radius of Ingham County, making venue in this court appropriate, that she did have interaction with the person she identified in the court today as Mr. Patrick Kane. She indicated that he showed up to her house. He was upset that she didn't wake up earlier, that they began fighting. She said she can't recall what they were fighting about, but the fight became this physical, and she just wanted to get the defendant out of her house, that he began to throw her around by grabbing her by her arms, that he placed his hands over her mouth. She testified on direct examination that she has some pre-existing sinus issues, so it caused difficulty for her to breathe. On cross-examination, when questioned about the sinus issue, she indicates that the sinus issues don't cause her difficulty to breathe. It should also be noted, though, that she did indicate that she doesn't even try to breathe through her sinuses because of her sinus issues. So in her head, she's thinking breathing means through her mouth. So if you put your hand over your mouth and you hit, that's what she uses to breathe, then that would cause impeding of her airflow. Nonetheless, there's sufficient probable cause as to count 1 for assault with intent to do great bodily harm, less than murder, or by strangulation, by assault or by strangulation or suffocation. Count 2, interfering with electronic communication. The victim testified that the defendant was at her house for about 4 hours. Eventually, she was falling asleep and getting up every time she would try to get to her phone to call for help. He would take the phone from her. When questioned as to who she was calling for help, she said, anyone who could help me. It's a pretty broad statement. The criminal jury instructions state that to prove this at trial beyond a reasonable doubt, the people would need to prove first the defendant prevented, obstructed, or delayed by any means the sending of an authorized communication through a telephone line or electronic medium of communication, that be in the internet, computer program, computer system, computer network, electronic medium of communication. It does not matter whether the communication was actually sent or received. Second, the people would need to prove beyond a reasonable doubt that the defendant did willfully and maliciously interfere or prevent, delay the means or sending of authorized communication. This means the defendant did the act on purpose with the intent to prevent, obstruct, or delay the communication. The question as to whether or not her attempts to call anyone for help, what would include an authorized anyone, is a question of fact for the jury or the judge at the circuit court to determine. The court is satisfied that there's sufficient probable cause as to count 2 that will be bound over to accompany count 1. Count 3, domestic violence. And there is a request to amend that to a domestic violence third offense notice. The official charging document in this file does place an habitual offender fourth offense notice here, indicating that the defendant has been previously convicted of a third offense domestic violence. The motion to amend count 3 to domestic violence third offense is granted. All 3 counts will be bound over to the circuit court. Are you going to provide an updated complaint?
Yes, Your Honor.
Okay, that will be a bind over date for January 17th.
Your Honor, just regarding the habitual offender third notice here, the domestic violence third, I don't think relying on the habitual notice is sufficient grounds for amending it to a domestic violence third, Your Honor, without some sort of certified copy or something along those lines regarding. And I originally thought that that's what the court indicated originally. I may have been inferring. But my understanding is that the binding over without any sort of proof of prior convictions or something like that, outside of the habitual offender notice, which is just a notice, Your Honor, there's no requirements for that in there. I don't think that's proper means for binding over on a domestic violence third.
Okay, so you're placing an objection because at the previous discussion, you withdrew the objection. But that was clearly based on your misunderstanding of what I was saying.
Yes, and I apologize, Your Honor. I misunderstood earlier. I apologize for that. But I would be objecting to that. Yes.
Okay. I'm happy to adjourn this or to get certified copy of a conviction.
Yes, Your Honor. I mean, I
Do
can
you
get,
want a conviction from all three or just the conviction for the third offense? Because my understanding is that if they charge it as a third offense, they don't typically provide a certified copy for domestic violence third offense. However, a felon in a possession or something like that, then they do provide a certified copy of a felony conviction. But I've never seen one for the purposes of a third offense domestic violence.
Your Honor, at this point, having not been provided any of these other documents or anything else along these lines, it just puts me in a position where I'm feeling just a touch blindsided at this point.
I get it. We can, I think the best thing to do is to continue this so that she can go back to her office. You can go back to your office.
No, Your Honor, I would ask that the court not do that at this time. My client's currently sitting here on dead time. Once again, this just serves to, even though the people have not brought forth the necessary evidence at this time, it does nothing more than hurt my client. Serving dead time at this point, and just continues this ongoing service of injustice towards my client. For that reason, Your Honor, we will not be objecting, or we withdraw the objection regarding the court's bind over on a domestic violence third at this time. So I'd ask the court bind over at this time, as the court originally instructed prior to my objection.
Okay, thank you. Again, the bind over date is going to be January 17th. Again, that's bind over as to count 1 and count 2 and count 3 amended to domestic violence third offense. The bind over date is the date that the circuit court receives the file from this court. It's not the date you need to appear in court at the circuit court. Okay, Mr. Kane? Your next court date over there will be a pre-trial. Your attorney will be made aware of that date. Do you have any questions?
We would like to address the court on one final matter, Your
Honor. Yes.
Thank you, Your Honor. As the court is aware, my client is currently on parole. We would ask the court to consider allowing him to be released to Jackson so he can take care of some of his parole violations here. It's also my understanding that it's, and I don't understand this, but from what my client says, it's easier for him to get medications in Jackson. He is being provided some medications here in Ingham County, but he's not able to get all of them at this time. I don't understand the full logistics of that, Your Honor. However, I do understand the fact that he wants to at least kind of get going regarding parole violations. He thinks that after today's hearing, this will likely have an effect on that parole, and he would just like that to begin, if at all possible. So we'd like the court to consider or ask if he could be released to Jackson, Your Honor.
But I hold him from being released to Jackson. His bond is 50,000 cash surety. He posts the bond and gets released.
Can't afford the bond, Your Honor.
You're not asking for me. You didn't ask for me to change the bond. You asked me to release him to Jackson. He can go to Jackson as soon as he posts his bond.
Correct, Your Honor. In that case, I apologize. If the court would consider reducing his bond, that would allow him to be released to Jackson. Obviously, he cannot pay that, so we'd be asking for some sort of PR bond or other means that would allow him to get out to Jackson, Your Honor. A conditional release or something along those lines.
The prosecution want to respond.
Your Honor, we would ask that bond remain the same in this case due to, again, the severity of the conduct from the defendant towards victim in this case. Additionally, based upon the facts Or based upon information from the police report in this case, there's some indication that Mr. Kane has a history of covering his GPS tether in tinfoil. So he poses significant flight risk, and so people would find it inappropriate to decrease bond in this case.
That was the information that was provided to the court at the time of arraignment, which is what the court relied on in setting its bond appropriately to not only secure the public and the alleged victim, but also to ensure his return. The court was provided some information that indicated that he had manipulated his MDOC tether. So I think bond as said is appropriate. 50,000 cash surety will continue. Of course, he can renew his motion for his bond over at the circuit court. Any additional matters for the record?
Other than the people, Your Honor. Thank
None
you.
from the defense. Thank you, ma'am.
Here's your exhibits.
Thank you.